My name is Charlie Burnham. I'm one of the lawyers here at Burnham Gorokhov. And in this video, I'm going to talk to you a little bit about proffers with the government and proffer agreements, which are a very important part of our white-collar criminal practice. Very simply, a proffer is a meeting between a client and the government, a U.S. attorney and agents. Sometimes it's referred to as a debrief. A proffer agreement is a written document between the client and the government that limits the government's ability to use statements made during the debrief. And in this discussion, I'm going to try to explain the ways in which a successful proffer can help your case, and also the ways in which an unsuccessful proffer can harm your case. And my discussion is going to cover four main areas relevant to this topic. First, I'm going to talk about some details about proffer agreements and the provisions they often contain. Secondly, we're going to talk a little bit about the preparation that goes into a proffer session to maximize the chances that it's successful for the client. We're going to talk a little bit, thirdly, about what a proffer session is like, who participates, how it works, and so on. And finally, and most importantly, we'll talk a little bit about the very important decision of whether or not a client should go to a proffer with the government and some of the strategic considerations that are involved in that decision. Okay, first, as I said before, a proffer agreement is an agreement executed between the client and the government that, as I said, limits the government's ability to use the client's statements. A proffer agreement, sometimes it's called a Queen for a Day letter, sometimes it's called an immunity letter. It needs to be distinguished quite sharply from a full-blown immunity agreement that prevents the government from bringing any charges. It is very much not that type of agreement. It's also very different from a plea agreement or a cooperation agreement, which is a totally different animal. And to try to put a little bit more concreteness on this discussion, I'll go over some of the important terms with you from the proffer agreement commonly used in the District of Maryland that I have with me right now. Now, before I get into this, it's important to note that all 53 U.S. attorneys' offices have their own version of this document. It's important before you make any important decisions to read the provisions in detail and see what they say, because they are different from state to state and office to office. But I'm going to talk to you about three important provisions from the Maryland document, some version of which are going to be present in any proffer agreement you're likely to see. So how does our proffer agreement start? I'll read the very first pertinent sentence. The government will not introduce proffer information, that means your statements, directly against your client in any criminal trial except under the following circumstances. So, no use of client statements, with 6 exceptions that it goes on to list, and we'll talk about 3 of them in a little bit of detail just to give you an idea. And I'll refer to these 3 exceptions for shorthand so you can help to remember them as the honesty exception, the impeachment exception, and finally the derivative use exception. We'll go through them in order. So first, what do I mean when I refer to the honesty exception? And I'll read just the pertinent part of that one to you as well. Here's what it says. If your client knowingly withholds material information from the government or otherwise is not completely truthful and candid during the proffer, the government may use proffer information against your client for any purpose. That's important. And the takeaway here is very simple. If you're not prepared to tell the truth and the whole truth, you should not go to the proffer session, because if you go in there with the intention of withholding information or of lying, chances are you're going to get caught, and that's going to work out badly for you, because if that happens, the proffer agreement you've just gone through the trouble to execute with the government is completely voided, and all of your statements, not just the untruthful ones, can later on be used against you. So that's important. That's the honesty exception, as I call it. What's the second exception? The second exception I refer to as the impeachment exception, and I'll read that one to you as well. If your client is a witness in any proceeding and gives testimony that is materially different from any proffer information, the attorney for the government or opposing party may use proffer information in cross-examination or rebuttal. So what does that mean in practical terms? I'll offer an example that I think will help illustrate it. Let's suppose that you're proffering with the government as a part of a fraud investigation. Let's say it's fraud at a large company and the government's trying to figure out who was responsible for it. And during that proffer session, the government agents ask you about a meeting where they think the fraud was discussed and whether or not you were present. And let's say you say, yes, I was present, but I was looking at my phone, I was thinking about other things, I wasn't really paying attention, so I'm not responsible for whatever fraud conspiracies were discussed at the meeting. Then let's suppose you later go to trial, facing these fraud charges, testify in your own defense, and say something to the effect of, actually, no, I wasn't at that meeting. If you were to make that statement in your testimony, under the terms of the provision I just read, on cross-examination, the United States Attorney could cross-examine you as follows. Isn't it true, Mr. So-and-so, that although you just told this jury that you weren't at this meeting, you met with our agents on such and such a date and admitted that in fact you were there? And you can imagine just how powerful that line of cross-examination could potentially be in front of a jury. Of course, maybe you could explain it and say, oh, well, I got mixed up or I thought better about it. But if you're already digging yourself out of a hole like that, that's a position that you don't want to be in a trial. So that's the impeachment exception. Finally, the last exception is the derivative use exception. And this is the last provision that I'll read to you from our agreement here that we're working from. And here's what it says. The government may make derivative use of proffer information. That is, the government is free to use proffer information to pursue this or any other investigation. And here, I'll offer you another example to illustrate how that works. Let's say you're involved in a public corruption investigation, and the government suspects you, being a government official, might have accepted bribes. And you go proffer with the government, and pursuant to your proffer agreement that you think protects you, you admit, yes, in fact, I did take a bribe from Mr. Smith, and I transferred the proceeds to my bank account in the Cayman Islands. Under the provision I just read, all the provisions in fact, the government cannot use your admission that you took a bribe against you at trial. But under the derivative use exception, what they can do is two things, at least. They can go question Mr. Smith, the bribor, and see what admissions he might be willing to make. And they can try to follow the money to your bank account in the Cayman Islands and try and subpoena those records or maybe even seize the funds and so on. So that's the derivative use exception. That's very important. Now, as I said, these are only 3 examples from one version of a proffer letter. There are more examples. They're a little different in every part of the country. So read the letter carefully, talk about it with your attorney. Okay. The next subject I'd like to talk about is some of the preparation that goes into making a successful proffer session with the government. What do you have to do? Now, in any criminal case, we're assuming you've already told your lawyer everything you know about the case. You wouldn't be even thinking about going to a proffer unless you'd done that. But when you're preparing for the proffer, you want to think specifically, not only have you told your attorney all your own personal recollections about what may have happened, but think of what other evidence may be out there, other witnesses, other documents that the government may have. Because after all, you don't know where the government is in their investigation. You don't know what they know, what they've subpoenaed. And one thing the government loves to do is try and catch people in lies by asking questions based on information they already have. So for example, let's say to take a fraud investigation again, and you have email traffic with various people that you think might be relevant. You want to tell your attorney that those emails are out there, that they might be material, and ideally try and share them if you still have them with your attorney. Because otherwise, you may go into your proffer session unawares, and the government will show up with a stack of your emails, and they'll begin showing them to you. Is this your email? Is this your address? What was this about? And you don't want to be caught off guard in that type of a situation. So tell your lawyer everything and really put on your thinking caps. Now, another form of preparation that we do with our clients is just to give those sorts of intangible pieces of advice to help really put your best foot forward. It's, after all, a proffer session involves people, it involves human beings, different personalities, and you want to make sure it goes well. And one example of some advice I always give to my clients is don't be afraid to say, I don't know. At a typical proffer, you're going to be questioned about events that may have happened years ago. You're going to be questioned about specific details. And human nature being what it is, human memory, you may not remember everything. And if you start trying to guess or speculate, then maybe you'll get it wrong. And possibly down the road, the government might wonder if you were being untruthful. So you don't even want to go down that road. So don't be afraid to say, I don't know. That's just one example of the sort of intangible preparation apart from the factual investigation of the case that's just so important. So that's preparation. Now, after you've done your preparation, signed your agreement, it's time to go to the proffer session itself. What does that look like? Well, typically it takes place at the U.S. Attorney's office, sometimes at the courthouse or another location, but usually it's at their office. Your attorney, if it's myself or another attorney, will go with you and be at your side throughout the meeting. On the other side, at a minimum, there'll be a United States attorney present, at least one federal agent, and maybe more lawyers and agents. You'll show up there in a conference room or other location. The U.S. attorney will go over the letter with you, some of which I just read to you, make sure everybody understands it, and then they'll get into the questioning. And what's important to remember, if at any point during the questioning something comes up you weren't expecting or that confuses you, you have a right as many times as you want to ask for a little break, to go out in the hall or have the agents go in the hall and talk to your attorney, and then you can resume. That happens all the time. So that's sort of the lay of the land for how these sessions look and work and who the characters are. Okay, finally, the fourth area that I said I would talk about, which is the most important and the most interesting, is how do you decide whether going to a proffer session is even a good idea for you at all as the client? And needless to say, this is a high-stakes, important decision that can only be made after a thorough investigation and discussion of the facts, talking to the government, doing all your homework, investigating the necessary law, potential defenses, exposure at sentencing, all of those things. So in no way in this video can I give you any kind of checklist or flow chart or exhaustive treatment of when you should talk and when you shouldn't. But what I will try to do is give you some broad outlines of how to go about making these decisions with your lawyer in an intelligent way. And I'll use 3 examples of scenarios and how they come out. So the first one will be if after talking to your lawyer, the decision is you haven't broken the law, the government is open to believing you haven't broken the law, and you're ready to go in there and explain to them your role in the case in hopes that it will clear your name. And I'll give a short example of how that might look in practice. Let's say you're a loan officer and you made a loan to a borrower who was later determined to have submitted fraudulent documents, inflated his income, lied, done whatever. And you know to a moral certainty that you were not at all privy or involved or on notice of this fraud. In fact, you were the victim. You talk to your lawyer about it, investigate the case. Your lawyer talks to the prosecutors, and it seems like they're reasonably open to hearing your side of the story. In that circumstance, it very well may be to your interest to go ahead and meet with the government pursuant to a proffer letter, explain your side of the story, and hopefully clear your name in their eyes. We've employed this strategy many, many times for different clients. It's always worked out well. Very often at the end of these sessions, the prosecutors will come and say, thank you for coming in. We think your client was truthful. We really appreciate it. And everybody's happy, which benefits the client because they know they're not a target and they don't have to deal with the stress of waiting for months or years to learn the outcome of the investigation. A federal investigation is an extremely stressful experience, and this is a way to sort of short-circuit that. So that's one example. Another example of where going to a proffer session can be of great benefit to a client. Let's say you're the client and you have, after talking to your lawyer, decided that you did break the law. You made a mistake, you made an error in judgment. Let's talk about another specific example. The Foreign Corrupt Practices Act is a federal law that prohibits bribes to foreign officials. So let's say you're doing business in another country. You're trying to close a deal, and the way things work in that country, to close a deal, you've got to give the local government official his cut, and you make the bad decision to do that, and you have reason to believe the government can prove it. And so you talk to your lawyer, and the decision is you want to go in, you want to cooperate, take responsibility for what you did, and try and minimize the damages of your mistake, whether that means a favorable plea agreement, a sentencing reduction, non-prosecution agreement, maybe no charges at all. It depends on, obviously, a wide variety of factors. The government probably is not going to agree to any of those favorable outcomes before having a chance to sit down, talk to you, judge your level of acceptance of responsibility, your honesty, your youthfulness to them as a cooperating witness. And so in that circumstance, if you've done all your homework and the necessary preparation, it very well may be to your benefit to go in and engage in a proffer session along the lines I've set forth. Okay, that's the second example. The final example I'll give is of a situation where it most likely is not going to be to your advantage as the client to proffer with the government. And let's go back for this to illustrate it to our loan officer example. Okay, so as I said before, you're the loan officer. You made a loan unknowingly to a borrower committing fraud who inflated his income. You do all the right things, you retain counsel that understands investigations, you talk to your lawyer, research the law. Your lawyer calls the government to ask about a proffer, and the prosecutor says, you know what, we're open to having a proffer, but if your client's going to come in here, you, Mr. Defense Attorney, your client's going to come in here and say he didn't know about the fraud, we're just simply not going to believe that. And believe it or not, prosecutors frequently do make statements to that effect in certain types of cases. In that circumstance, unlike my first example, it's probably not going to be to the client's advantage to go in and talk under a proffer agreement or otherwise, because what's going to happen? You know, or you have a good reason to suspect, that the prosecutors or the agents are not going to believe the statements. They may say that you breached the agreement by breaching the honesty provision that I mentioned before. They can use your statements against you at trial if there is one, in cross-examination, as I discussed before, all of those things. And you're certainly not going to get any kind of favorable disposition. So that's a circumstance where it may well not be in a client's interest to go in and proffer. Anyway, these are 3 of probably 200 different permutations of types of cases where the calculations are different, but hopefully they give you sort of the flavor of how these decisions are made. And the takeaway is, going back to my third example, where proffering is not to your interest. That is the #1 way that we've seen where clients can harm their cases. They treat the proffer agreement and the proffer session as sort of a free pass to go in and try and talk themselves out of a bad situation. And sometimes they do so, if they don't have good legal advice, without doing the necessary homework to figure out if the proffer is to their advantage and laying the groundwork to make it successful. So that's the takeaway. Don't mess up your case by doing an ill-advised proffer, and don't pass up an opportunity for a favorable resolution by declining to proffer when you should. I hope this video has been helpful. Obviously, it's a broad overview. If you want to talk to a lawyer in more detail about your particular case, feel free to reach out to us for a consultation. We've done many of these proffer sessions in every conceivable situation all around the country with all the major law enforcement agencies. We've seen it all, and hopefully we can be helpful to you and your situation. I hope you enjoyed this video. I hope you found it informative, and thank you for watching.